Hi, my name is Rajesh Parajali. We have 5 group members in our group assignment. I'm going to talk about the partnership. For the first question, are Lucy Simmons and Co carrying on a partnership? Yes, Lucy Simmons and Co are carrying on a partnership business on previous agreed term and condition. In the case study, it is mentioned that they were registered their business name Luceco. It may be assumed that their partnership was registered business which may be legally suited in case of any dispute. According to the sections 6 and 7 of Partnership Act 1963, since all formation of a partnership requires 2 or more peoples to agree to start business for making a financial profit, Lucy Simmons and Co. are eligible to enter into a partnership agreement for doing the business of cutting the grass of clients. As all the 3 individuals have agreed in their mutual consent of the partnership, it may be said that they are now legally bound by the terms of agreement. Yes, they are liable to contribute to the purchase of Brighton Mall. According to the section 13 and 14 of the Partnership Act 1963, as Lucy Simmons and Co. have entered into general partnership agreement by register their business named Luceco, all the 3 individuals are liable for the Luceco debt, such as purchase of right on mower from Pascal. Whereas if a partnership agreement had been signed with the cause of limited liability, then Lucy and Co. will be liable for purchase of right on mower to the extent of their capital contribution to the firm Luceco. They have to bear all the debt of the firm on the occasion of Simmons' death if not agreed upon earlier.
I'm Kausar Mishraji. Firstly, I'm going to talk about the question: is Lucy in breach of partnership duties as a result of carrying out her weekend work? So, so when 2 or more people entered into a partnership agreement, they are legally bound to inform each other before taking any business decision. It is also mentioned in the Partnership Act 1963 that no existing partner should use the client base or the business name of the present partner's partnership firm for his or her own personal business in the mutual benefit of the present firm as Luceco. If he or she uses secretly, then it should be referred to as a case of breach of partnership by that particular partner and is liable for a penalty. According to the Partnership Act 1963, Section A and Section 34 1A and B, Lucy has deliberately used the client base of Luceco and secretly accepted payments in her personal bank account. This is thus it may be stated that Lucy has breached the partnership duties as secretly using the client base. And in my second part, I'm going to talk about if Fastcut wishes to take. The question is if Fastcut wishes to take legal action against Luceco to recover the purchase price of the right on mower, how could Fastcut discuss who the individual are behind the business? So, as the business registered at Luceco, it isn't necessary to know the name of the partners to file a case. Fastcut can file a case against Luceco to recover the purchase price without mentioning the partner's name. He can proceed with the Luceco name, the partnership name, the business name. If he really wants to know the name of the people behind the business, then he can apply to the court about regarding the issue. And in this case, FastCut needs to proceed further as per the rules prescribed by the relevant partnership law of that region.
Hi, I'm Wasimo. Hi. So I'll be talking about the effect. What effect does Siemens death have on the partnership? So Siemens death will impact the partnership of Leosco because according to the law, the partnership may be dissolved if a partner die or get bankrupt. As long as the other partners agree to continue the business or to the dissolution. So hence in this case, if the other two people of Leosco, Lucy and Co decides to continue the partnership, they can do that eventually. On the other hand, if Lucy and Co decide to continue the partnership, they can do it as well. Okay, so now I'll be talking about what would Lucy and Co determine what is a partnership property, how they're going to determine what is partnership property, and how would they the partnership property be used to meet the Luesco losses. So according to the rule number 1 section 6, the tools and machines which are completely owned by the partnership firm are like Lucy and Co will consider the remaining amount of the partnership, and the machines which are used are owned by the company to calculate its assets. So also if there's a due which cannot be paid by the assets or by the partners, as a result of which the partners will be liable to pay the remaining amount of the due for their own property. First, the amount of the partnership will be in the bank accounts and will be confiscated. Then the asset which is used has the remaining partners of the partnership will be liable to pay the remaining balance in their own accounts. So thank you, that's for my part.
Hello everyone, my name is Kapil Devadikari and I will discuss question number 2 in our assignment. In question number 2 there is a case and I will first explain that case briefly. Swimming Pool Company Private Limited employs Martin as the manager of their Tasmanian sales division. As a manager, his duty was to quote to potential customers on the cost of installing the various pools that the company offers, draw up any new contracts on behalf of the company, and as a manager he need to ensure that a deposit is paid by potential customers. These monies are then deposited in the company's bank account. As a manager during his job he received fixed salary, but contract shows he will be entitled for bonus if he exceeds his annual target. During first month of his job, the company is very impressed because he has signed at least 20 new customers and work has begun on at least half of the new projects signed. In the next month, company received number of complaints from the customers. Some of the customers complained that their swimming pool is substantially different to what they had constructed. Some other customers they made complaint that wrong advice has given to place of their new swimming pool. It also appears in front of company that he didn't deposited the received amount from the customer in company's bank account. Another thing, they discovered that Martin is in process of setting up his own business which will compete with Swimming Pool Corporation. Now I will explain the question number 2a, where it has been asked that is Swimming Pool Company liable for Martin's action? On what basis in law would this be the case? In accordance with the case, it has been evident that third party received damage by Martin, employee of Swimming Corporation Private Limited. According to tort law, the company is liable to due course of their employment. It has been evident that Martin is found guilty, and as an employer, Swimming Co. Private Limited will be liable, as liability is termed as vicarious liability under the law of tort. According to this law, if an employee breach their duties, act unethical, brought damage to the third party, employee will be liable for such actions. Employer will be liable for under the common law. The case shows that the employee performed financial ethical breach, and as an employer, Swimming Pool Company Private Limited will be held liable as part of tort law. As a result, company will be charged for breaching and violating vicarious liability. Now I will discuss next question, which is question number 2b. In this question it has been asked, can the company claim they are not liable for Martin because he has not followed the instruction? On the basis of the stated fact where it shows that Martin has breached number of duties, and this can be argued legally in different ways, but according to the evidence, Swimming Pool Company Private Limited can defend themselves and can prove that they did not authorize any employee to act unethical and causes damage to third party. To prove this, company can argue that Martin did not deposited advance payment to company's bank account. Company cannot allow any employee to damage their goodwill and affect their business. Conclusively stated that Swimming Pool Co. Private Limited can claim for is not to be held misconduct and offensive of Martin.
Hi, my name is Praveen Shrestha. I'm going to talk about question number C and question number D. Let's start with question number C, and the question is like, is Martin liable to the employer for any of his action? On what basis in law would he be liable? And the answer is yes, the Martin is liable to his employer as he was appointed to the sales division in order to raise the customer's volume by convincing them to purchase the swimming plots and increase their new contracts in accordance to maintain the net income on the behalf of the company. Taking all the responsibility and roles of the sales manager consideration, it can be said that it was Martin's responsibility to identify the leakage regarding the purchase plots for which customers cannot suffer for investing money on an unappropriate land. However, he was not liable for the bad construction and infrastructure dispute and the bad material which were used to build the other swimming pools in Rexburg. It is to be noted that under the Act of Civil Liability Act 2002 Section 5Q, in any circumstance, company or employer will be liable for all the wrongdoing, as it is vicarious liability of the employer and the company employs Martin. Notably, Betty Samuelson and April 2018 said that an organization is bound to compensate for the damage the employer done to the third party or customer during the course of employment. Thus, it can be stated that the company is liable to pay the third party compensation so that the parties cannot file the charge against the company. It can also harm the brand image of the company, and the customer and investors cannot pay any attention in long orientation. And let's move on to the second one. And the question is like, has Martin breached any law if he is planning to set up his business? And then we have to explain on this one, and I'm gonna explain on this question. As a Martin has appointed as the manager of sales division, through which it is expected that Martin grabbed the idea through which he can easily launch the same business by using the same business process. In order to comply with this, it can be stated that Martin breached the business objectives and outline of internal structure for which he used to not pay the responsibility, and his lack of irresponsibility and create the liability for the company. The company has thereby mitigated the third party of obligation by repaying their amount of money and compensate their loss to protect the company reputation. Thank you so much.